Here's something that happens right at the end of a lawsuit sometimes, and I think a lot of lawyers fall into a trap, and the problem is that they take their clients with them. What am I talking about? It's secrecy agreements, confidentiality agreements at the end of a case. This happens when the defendant has offered the client and the lawyer sometimes pretty big money to settle a case, and then they just say one thing at the end. They say, oh, by the way, we'll just need complete confidentiality. Well, what does that mean? That's part of the problem. Sometimes it just means, look, the amount of the settlement is confidential, and that's good for our clients because they don't want their neighbors and relatives and Uncle Joe to know exactly how much money they've got out of a case. So we agree to that pretty easily because that's in our client's best interest. But many times defendants take it a step further and they say, we want this whole case, this whole episode to be kind of wiped out from the face of the earth as if it never happened. The lawsuit never happened. All the facts you've learned, none of that happened. And the way we enforce it is you, the plaintiff, the injured person, the family of the injured person, and your lawyers, you can't say one word about this for the rest of your lives. And they'll ask you to enter an agreement like that. Typically, they don't do that until they've got the money on the table and you can kind of smell the money, and they tempt you with the money to do something that you wouldn't do otherwise. Why is it bad for people? Look, lots of times people don't want to talk about some traumatic event, and that's fine. I believe in total freedom along that line. What I don't like is when defendants try to force a muzzle on my clients and prevent them from talking about something that was important in their lives, that was a shaping event, and then they can't tell anybody about it. So that's just not fair, and it can have some bad repercussions. Let's say you enter into one of these secrecy agreements and you promise never to tell anybody about your case. Well, you could be at a party or something 2-3 years later, and somebody comes up to you who hasn't seen you in a while, and they say, hey, I heard you had this legal case. What happened with that? And then you start telling them about it. Oops! All of a sudden you realize, wait a second, I just violated the secrecy agreement. Well, sometimes that can be innocent and nothing ever happens about it. But what if you've sued somebody who's just looking for trouble and looking for a way to mess you up because they resent the fact that they had to pay you money to settle your lawsuit? They find out about that, and they can try to put you in trouble for violating the secrecy agreement. So it's just a real can of worms, and I try not to get involved with that. I think the ethical thing for lawyers to do is to say, look, we'll agree to confidentiality of numbers, but in terms of the public record, because the complaint is filed in a public court and there are other kinds of documents that get filed in court, all of that has to stay on the public record because otherwise you're trying to sanitize what happened. The other important thing is that sometimes other people need to know what happened in order to A, protect themselves so it doesn't happen to them, or B, if something bad has happened with the same defendant with them, they may need to get evidence from you. And so that's why it's important that people be free to share evidence between different victims and their lawyers. So it's just a bad thing all around to have these confidentiality agreements, and that's why I feel pretty strongly about it. We've taken a stand on it. We've got a page on our website about it. I've written articles about it, and I've talked to lawyers all around the country about it because I don't think it's good for lawyers either, but it's especially bad for clients. Thank you.